Blurred Faces, Markshots, and the law. Are law enforcement breaking and violating the presumption of innocence rights of suspects or accused persons when they take pictures of them and put it out in the public? This is the law. It's your legal light. It is your help law. We write back to help you with platinum legal education. Welcome back. In the course of this week, the Office of Special Prosecutor, the OSP, put out a mugshot containing the photographs, the images, and names of a number of individuals. It says it had put before court charged with corruption-related offenses. And then the debate, as always, started. The special prosecutor was being lawless. Is that correct? Is that accurate? What's the place of mugshots in the law? What are the limits? The police have also been doing something like that. They take photographs of the accused persons or the suspects and they blur their faces. Looks like we are comfortable with that. Why? These are the matters engaging our attention this afternoon. And I'm excited to welcome to the studio Samuel Kofi Nartey, who is editor of the Ghana Law Hub. Sammy, thanks very much for making time to join us.
Thank you, Samson.
We also have, and we'll be hearing from Korea Dodu, who is senior partner, Egality Law. He is based in the UK and also practices here in Ghana as well. So maybe we'll start by getting to appreciate the matter that brought up the public outcry. So let's see the mugshots put out by the Office of the Special Prosecutor in the course of this week concerning Mustafa Hamid, the former boss at NPA, National Petroleum Authority. So that's in your shot. He, together with 6 others, have been charged with criminal offenses involving corruption. Mustafa Abdul Hamid and 9 others. So the case is entitled Republic versus Mustafa Abdul Hamid and 9 others. This is what came up and got people talking. Many have criticized this as a wrong thing to do. There were publications, and social media also went, agog. One of the publications I'm projecting to you tells you that social media drags Office of Special Prosecutor over mugshots. You'll see that shortly, and then we'll begin talking. It says OSP dragged on social media over mugshot posts of accused persons. So there was outrage that this is completely wrong. It should not be done. Right. So let's begin talking. And I want us to begin from Korea Dodu, senior partner at Egality Law. He practices in Ghana, but is based in the United Kingdom, where he also practices the law. Let's get a feel of how things happen over there.
My view is that when a person is charged,
that is quite different from being a suspect. There's a significant difference when you are the subject of the court process. So insofar as you have been charged, that means that the criminal process is going to be commencing against you. That is a public process. Criminal trial and the criminal procedure before that are matters of public record. So where the special prosecutor has charged an individual, it is indeed in the public interest that the public be informed of that, because public oversight of the actions of official bodies is a critical part of a democratic society, and the ability of the public to scrutinize and ensure that due process is followed. So actually, it is in the public interest that we know when someone has been charged and is subject to the machinations of the law, what their process will be and how the officials and the authorities are going to deal with the matter. I think that's very, very different from merely being a suspect. When investigations are ongoing, then that is an entirely separate matter. Those investigations may or may not lead to charge. And to draw an analogy, it's a little bit like saying that because someone is subject to investigation by the police, they should be publicized, they should have the issue published. Well, compare it to an audit of a private company by its auditors. There's nothing public about that process at all. It is a form of investigation to check that the company is indeed going about its business in a lawful manner, but it is not something which everyone in public is entitled to know about. The ins and outs of an audit, which is a legal requirement, do not require that the public be informed of those details. The counter-argument is that the police are public officials, and when they suspect someone and when they're investigating them, there should be some record or interest in that from the public. I think it's a very important balance to strike, and generally speaking, the balance should be struck in favor of the privacy of those who are suspected, because of course, being cast with suspicion and having your name or your face published in a newspaper merely because you are a suspect can be extremely damaging to reputation. And it's also been found to be an invasion of privacy. For example, in English law now, it is recognized that being a suspect in an investigation is a matter for which someone has potentially a reasonable expectation of privacy. So Cliff Richard, the famous musician, brought a case against the BBC because he was under suspicion for an alleged criminal offense, and had the police raid his house. They hadn't charged him with anything. And the BBC managed to procure a helicopter to fly above and film aspects of the raid. And he succeeded in claiming before the UK courts that that was a serious invasion of his right to privacy. And we have a right to privacy in the Ghanaian constitution. And that is an argument that could be made one day, that if you publish details of my being investigated when I haven't been charged with anything, that is a violation of my right to privacy. Thank you.
So, sorry? Do you share the view by Korea Dodu, senior partner, Equality at Law? He says that there may be some constraints in respect of suspects, but once the person is charged, the process will already be a matter of for the public. So there's no breach.
Yeah, I think there's an overriding rule in the criminal justice system. There are two rules. First of all, the fact that the court is accessible to citizens and to the general public, as well as the media. Right. So you find out that in our constitution, trials must be conducted in public except when there are overriding interests. So, for example, cases involving juveniles, or for example, matrimonial matters. The second element has to do with the fact that there is a right that the public has to know what is going on in the court. And so the information is that the citizens would rely on reportage, for example, from the media. So there is that public interest by these people. So we can't say that because someone is a suspect or someone is an accused person or someone is being investigated, citizens do not have a right to know. Citizens have a right to know. The issue has to do with the scope of the information that is released, and that may have serious ramifications for the presumption of innocence of accused persons.
I'm going to get to the Constitution so that we can, for example, attempt to project the question whether or not the provisions of the Constitution are breached. As you said, the Constitution in Article 19 calls for fair trial, and in that process makes what we already know. That is Article 19, Clause 2C. It says, a person charged with a criminal offense shall be presumed to be innocent until he is proved or has pleaded guilty. Isn't there a fine line between this and projecting them in the public?
So I think going to Article 19 straight does not help us to appreciate the issue. We must start from Article 15.
15, okay.
So Article 15 tells us that the dignity of all persons is inviolable. So it is on that basis that law enforcement cannot even mistreat you when they arrest you. Now, Article 15 also tells us that the law enforcement cannot do anything that distracts or is likely to detract from this dignity that we are entitled to.
Right.
So if we understand that this is the basis under which law enforcement agencies must act, then we can move a step further to Article 19.2c. Now, when you have Article 19.2c, the question that arises is what is the duty imposed on the court as well as prosecutors in terms of this particular provision? And this particular provision has two implications. First, the allocation of the burden of proof. So, because the accused person does not have to do anything, does not need to give in even a testimony, the prosecution has a higher burden of establishing or producing or adducing evidence to establish the guilt or otherwise of the accused person. And so, if the prosecution does not lead evidence, then the accused person will walk free. The second aspect of the presumption of innocence has to do with the fact that the jury or the judge cannot use any evidence outside the scope of evidence that is before him or her. So you cannot have a situation where the prosecution has sort of tendered exhibits A, B, C, and the jury or the judge is relying on exhibit X, Y, Z. That will go against the presumption of innocence. So if we look at the presumption of innocence, that's how we should see the presumption of innocence. So the question that would arise in this instance is, does the publication of the Markshots undermine this presumption of innocence? And I say it undermines it on two grounds. First of all, as Korea said, the Constitution guarantees the right to privacy. So our right to privacy is allowed. So on a normal day, nobody can take a photograph of me without my consent. Unless, of course, I go to a public place. If I go to the stadium and there's a picture, or I go to a concert and there's a video of me, I cannot say that my right to privacy has been breached because it is reasonably necessary in those circumstances. So if you go to the police arrest you naturally, the police will take your fingerprints because these are necessary for law enforcement. They'll take a photograph of you. Now, something, can the police release your fingerprints to the general public? If we cannot answer that question, then how do we say that the release of Markshots does not violate the presumption of innocence? Because the police generally cannot release. Now, something, I think one thing that we have to pay attention to is the Data Protection Act. Now, under Section 37(1)(b), a person shall not process personal data which relates to criminal behavior of a person. So if you look at the definition of what constitutes personal data, imagery is part of it. Now, this means that when the police arrest you, that information that Markshot pictures that they take is for their work. Now, how does this work? How would they use this information? So, for example, you have been arrested and you jump bail. The last picture that they have of you is that particular picture.
Okay.
And so if they publish that picture that you are wanted, it will be reasonably necessary in the circumstances for the discharge of their duties. Or, for example, you are someone who you are likely to cause further injury to the public. And so that picture will be useful for purposes of saying that, look, this person has this history, this person has done this, and we think that this person is likely to do X, Y, Z. So if you look at Section 37(1)(b), the publication of that personal data can only be justified if it is necessary in the circumstances, or if the person consents to the processing of the personal data, or if the exercise of the performance of that right is an obligation imposed or conferred by law. So the question that we have to ask is, does the OSP or does the police have a right under law to publish such images of accused persons or suspects? The question is that the answer to me is that they don't have that right, because the use of that image is likely to have unintended consequences. Now, if you take a look at the pictures carefully that the OSP published, you can see different facial expressions of the accused persons. Something, you're a practitioner in the courts. Now, I know very well that if your client is arrested for any other or for some serious offense, you tell your client how to dress to court. True or false? So you understand that the way the client appears in court is likely to have an impact on his trial, because the judges are human beings. So if the accused person is said to have embezzled 24 million Ghana cedis, and the accused person, a picture of him is taken, and he's smiling, what image does that picture create in the eyes of the jury, if it's a jury trial? What image does it create in the eyes of the judge? The judge is a human being. You can't say that the judge is only going to rely on the law, but there may be extra matters which has a likely impact on the administration of justice. So these things must not be taken lightly.
So back to an emphasis on your points.
Yeah.
Your point is that releasing the Markshots into the public, whether the person is a suspect or has been charged, is irrelevant.
It's irrelevant.
It is unlawful.
It's lawful.
And your basis of saying that is unlawful is that they are entitled to be presumed to be innocent.
Exactly.
Until the court has found them guilty.
Yes.
Right. So now let's do a little exercise. Watch these other Markshots from the US, where persons who have been arrested and their Markshots have been taken and it is put out in the public. You watch that first, and then you remember that not too long ago, President Trump was in trouble.
Yes.
And he also had his Markshots.
Yes.
In fact, now what he has decided to do is that he has exhibited his Markshots
The White House.
in the White House. You know, the controversial President Trump. So these are Markshots that in the US and elsewhere, they do take, law enforcement do take, and actually put them out there, release them.
Yes.
When President Trump had his mugshot taking, this is how the BBC reported it. I'd like you to look at that reporting as well. The BBC said, historic Trump mugshot released after arrest in Atlanta, Georgia.
Yeah.
So, what's the difference?
The difference is the states in which they were arrested. Trump was arrested in Atlanta, Georgia. In Atlanta, the law enforcement has a right to release the Markshots. So the question that we have to ask ourselves is that under what law is the OSP acting? Under what law will the Ghana Police Service be acting? Something, let me refer you to a decision by the US Supreme Court.
Before we go to the decision, you have just asked the question, under what law?
Yes.
When Korea Dodo was speaking, he referred to a decision as well, which says that once they are charged, their mugshots can be put out there, which appears to be the general view which you are against. Yes. And that general view does not even seem to go far enough, or appears to even go too far, because there are others, like you have just said, in Atlanta, Georgia, upon arrest, the mugshot is taken, and then it could get released. What law specifically says, take a mugshot and release it?
Something.
In those circumstances. Will you find a law that says, take a mugshot, release it?
In the US?
Yes.
They have the Freedom of Information Act. So people from media organizations, for example, can call for it. And the reason why there was a case in which, between the Times versus the US Department of State.
Okay.
Now, the Times needed the mugshot of a very popular American who had been arrested for treason felony, which would, under our laws specifically. Now, this is what the court is saying. A mugshot is more than just another photograph of a person. Mugshots in general are notorious for their visual association of a person with criminal activity. Whether because of the unpleasant circumstances of the event or because of the equipment used, mugshots generally disclose unflattering facial expressions. They include front and profile shots, a backdrop with lines showing height, and arguably most humiliating of all, a sign under the accused's face with a unique Marshal Service criminal identification number. Now, the court declined the media organization access to this mugshot. And the media organization was challenging this decision by the US State Department because, in their view, this popular person was being treated differently from other accused persons. Their contention was that the mugshot that was released was a mugshot that was after the trial and was a picture not when he was arrested. The court said it's insignificant.
So
now,
a
small point. Now, this decision had relied heavily on a US Supreme Court decision on what they term rap sheets. So normally, if you are arrested, you are profiled, your details are taken. The issue was whether the justice system could release these rap sheets to people. The Supreme Court says that the so-called rap sheets could be withheld from journalists, given the privacy interests of the individuals involved. So we're saying that there's an overriding interest. There's a balance that law enforcement must
Right.
work.
So you said the jurisdictions where they release it. You spoke to Freedom of Information, acts, right?
Yeah.
In Ghana, we also have the same.
Yes.
The Right to Information
Yes.
Act. So what's the difference?
Section 7. You cannot disclose information which may impede the prosecution of an offense.
Impede.
Impede the prosecution of an offense or prejudice the fair trial of a person or the impartial adjudication of a case. So Samson, back again to the question I asked you. If your client is charged with murder, would you tell me that you ask your client to walk to court in suit and tie?
So you realize, I'll ask you a couple of questions because we're building on, because my view on this is already known, that once you're charged, the global position, which is that a Markshot can be put out, is where I stand, together with a courier. So how about Section 17 of the Right to Information Act? There is public interest.
Yes.
And if there is public interest in a matter, and that interest, the law says, if it overrides, it outweighs whatever interests there are, then the public, purpose should prevail, correct?
Yes. So, Samson, the question is, what is the public interest here? The public interest is that the public want to know what offense the person has been charged with. Who is the person who is accused, who has been accused? So, releasing the person's name does not breach the right to information.
Okay.
Releasing the charges that have been given does not breach it. But I'm saying to you that the moment you take a mark shot and you release that photograph, it impedes the fair trial of the person. And I'm just saying to you that photographs have a way of being interpreted. You cannot misinterpret my name. You cannot misinterpret the charges. But I'm saying to you, if an accused person has been charged with stealing 24 million Ghana cedis, and you put a picture out there where he is smiling, if a judge or a jury sees this, there's nothing that the defense counsel can say to the jury that this smiling picture of the accused person does not mean that he knows what he did.
So the prejudice you are talking about is a prejudice that is not about the public.
No.
It's not about the public. So it's not what the public would think.
It's not what the public would think, because remember...
But what the jury or the judge would think.
Exactly, because I'm saying to you that there's a presumption of innocence.
Right.
And the presumption of innocence is that the accused person, the judge, must consider the evidence before him.
So hold on. If putting the name out is fine, as far as you are concerned.
Yes.
Putting out the charges out is fine, as far as you are concerned. But putting out the photograph is the problem. And you say putting it out has a potential to prejudice the trial, the fair trial of the person. And now you confirm that your concern is not about what the public will think, but what the jury or the judge will think, correct?
Yes.
Okay. When a judge or a jury are determining a case, you said a while ago, they are supposed to stay within the confines of what is brought to the courtroom and not what is outside, correct?
Yes.
They will see this accused person appear before them 1, 2, 3, maybe 100 times. So why will they be concerned about his photograph rather than, I don't get that, explain that.
Something. The law is not just what is written on paper. When the jury is taking decisions or when the judge is taking decisions, there may be extra legal matters which may affect the judge's decision. So we cannot take it lightly. That is why I say that Article 19(2)(c) says that there is the presumption of innocence. Other than that, everybody, once you are charged, you will be convicted.
All right.
Because the fair trial rules are made for a purpose. And the purpose is that, look, we have to give everyone the benefit of the doubt. So let me give you an example. What if that after the person is acquitted and discharged, what happens to the picture?
Hold on, slowly. Your picture as the Markshots, if I can have the Markshots back, I want to ask a question that is illustrating.
Yes.
That this Markshot is put out, or like Trump's that we have seen, that is put out. After Trump gets discharged and acquitted, what are you saying? That because of the Markshot and it having been published, people will still say he's guilty when the court has acquitted and discharged him? No.
I'm saying to you, now, this is the BBC report. Now, you can check the CBS report on this particular Markshot. The CBS said that Trump puts up a face of defiance. That was the CBS. All the other persons who were charged with Trump were smiling.
Stay with the substance.
Yes.
That this is a Markshot
yes.
of the accused person. Yes. And you say putting it out prejudices their fair trial because they may carry a smiling face when they are being charged with a serious offense. And the question I ask is, in that regard, your argument and contention is that the prejudice you are talking about is not about what the public see the photograph to be about, but what the judge or the jury will see. And I ask the question, in the courtroom, the judge and the jury are supposed to limit themselves to the, you said that a while ago, to the things that are brought before them in court. And they would have seen this accused person appear before them about 100 times perhaps before they come to the judgment. So why would they say the picture that was put out, he was smiling, and that is what we'll use against him, rather than when the person appeared before them and even was testifying and answered questions that they should rely on?
First impressions are important. First impressions are important. That's why I asked you, if you have a bail application for a murder trial, are you going to ask your client to put on certain outfits to court?
Okay. Once again, you say the name, when the name is put out, you are fine with it.
Let me come to
let me get this. Once the name is put out, you don't have any problem with the name.
You can't.
So how about this officer who is a politician?
Yes.
Trump, who is a politician.
Well known.
We have Markshots of Tupac, whoever they are. Recently, Diddy, all of them, Markshots put out in the public. My question is it that they would not have been known but for the Markshots?
No.
That's why you have a problem with the Markshot but not the name.
Something, I think you have to separate two things. First of all, does the law permit you to disclose the Markshot? It's a different question as opposed to whether or not you can take the Markshots in the first place. And if the law permits you, I'm saying that prejudice or whatever you are talking about has already been addressed by the law.
Okay.
We don't have that.
We don't have what?
We don't have the right. The law enforcement does not have the right to disclose that image. And I'm saying to you...
You can't show me that law.
I'm just saying to you that I've read to you because the Data Protection Act.
When you refer to the Data Protection Act, also has exemptions.
Yes, I have read. So I'm saying
that's like the right information.
That's what I'm saying, is that the exemptions would only relate if it is reasonably necessary in the circumstance. And I'm saying to you, if the law enforcement officer takes a Markshot of you and you jump bail, what's the last image they would use? The Markshot. Exactly, because that is the last, because maybe you might have changed in the last 3 months. Maybe you posted a picture on social media 6 months ago. Right. So that picture is necessary. And I'm saying to you, if the police cannot release your fingerprint to the public, how can the police release your photograph? The definition of a Markshot, as I've explained in the US decisions, is very clear. So you can't pick and choose which ones you want to, because this is a picture and this is something else.
But you have used the other jurisdictions.
Yes.
Where this happens. It's like standard, it's ordinary, it's normal that goes on. We just said Korea Dodu give that this is the standard. Once the person is charged, they can release the mugshot. And again, there was a court decision. He refers to that court decision, and that court decision said, if the person is charged, then there is no prohibition from releasing. That brings me to the question. They release a mugshot. You are attending court. The court is an open place.
Yes.
Any member of the public can go show up in the court and
Perfect.
see you.
Perfect.
In fact, as the trial is going on, the media will attend. They will take, videos, footages, and they will show. They don't breach any law. Tell me, how is this different?
It will not be part of the evidence on record. Would it be part of the evidence on record? It will not be part.
Is the mugshot part?
It's likely to be part of the evidence of the
Why?
record. I'm saying to you that the mugshot will likely be part of the evidence of record. If the person's statement is taken, this is what the person has done. It's likely to be part of the evidence of record.
I don't see how.
So the question is, I'm saying to you that the question, the issue, for example, if you look at, I give you a classic example.
Right.
Superstar Thomas Partey was recently charged by the Crown prosecution. Have you seen a mugshot? He's been, according to reports, he was arrested 7 times over the last 2 years. Have you seen a mugshot release? The Crown prosecution released a statement. Partey has been charged with 5 counts of rape and sexual assault. These allegations relate to 3 separate women. They conclude. Simple statement. I'm saying to you that the justice system, an accused person is not like any ordinary person. You are talking about somebody's liberty. You are talking about somebody's life. So the person may lose his life, the person may lose his liberty, right to movement. So what if you look at Article 19 specifically? Article 19 sets out so many conditions, even to give the person that, look, you have to give the person the opportunity and even resources to be able to defend himself.
I understand that.
So don't do anything that undermines the person's right to defend himself.
And I need you to convince me that Samson Ladi Anyanini has been arrested. He has been charged with an offense. The law enforcement put up his picture, put his name there. You're okay with my name being there. They put the charges I face. You're okay with that there. But you are not okay with my image. That's the question I ask. What does my image in fact do? Because I will be attending to the court, which is a public place anyway. And I am known, perhaps. So what does it change? So let's give examples. In the Houston versus Maricopa County, this is a very recent matter, 2024. A U.S. state court ruled against the publication of booking photos as mugshots, right? Of uncharged pretrial detainees, citing privacy concerns, but affirmed the permissibility of publication once formal charges have been filed. This is the general position I am advancing to you, that generally, once there is a charge, mugshots are allowed. In ZWX versus Bloomberg, 2022, we go to the UK, where you are interested in. The UK Supreme Court held that individuals under investigation generally retain a reasonable expectation of privacy. However, this expectation may be, they said, quote, significantly reduced, perhaps even extinguished, end quote, where the allegations are public or once formal charges are brought. If someone is accused of corruption, it is an offense against the state, right?
Yes.
Corruption is a matter of public interest, correct?
Correct.
So what should be the inhibition?
Sometimes there's no inhibition on, there are so many tools available for corruption-related offenses.
Okay.
So if somebody has been charged with corruption, obviously the state is interested, the public is interested. The media would cover it necessarily. These are people's funds. But the fact that somebody has been charged does not mean the person is guilty, because the prosecution would have to still go through all the protocols to establish the guilt of the accused person. So if the accused person is not guilty at the end of the trial, the accused person will walk. So the fact that the person has been charged does not change the nomenclature of the offense or whether or not the accused person actually did the act. What is important is the fact that I'm saying to you that we must at all times do acts which in the circumstances do not prejudice the fair administration of trial. Because the risk you run is the fact that there is a potential that the accused person will be prejudiced in the trial.
Someone wrote this, and some of the references I made from this piece. The principle played out in the high-profile Georgia election interference case, where the Markshots of former President Donald Trump and all his co-defendants, including lawyers, Rudy Giuliani, Jenna Ellis, Sidney Powell, and others, were publicly released by the Fulton County Sheriff's Office. I was actually watching those processes. Despite the political sensitivity and global attention, there were no legal challenges or public uproar over the publication of those mugshots. The accused were all public figures, already widely known. Notably, while recent U.S. rulings emphasize privacy protections, they also confirm that where compelling public interest exists, disclosure may be justified, assessed on a case-by-case basis, even after the charges have been filed. Then he makes the argument that in Ghana, I think this is a section you refer to, Section 108 of the Criminal and Other Offences Procedure Act permits law enforcement to take photographs and fingerprints of persons in lawful custody for offences punishable by imprisonment. Crucially, the same section mandates the destruction of such records if the person is acquitted. So you were asking, what do you do if the person is acquitted? So the records are supposed to be destroyed, signaling that the state must not only erase the record, but also publicly reflect the acquittal with the same prominence as the charge. Once charged, however, an accused person cannot lawfully refuse to be photographed. I read this final one. We open the phone lines. Let our viewers join us with any questions or contributions. In the fight against corruption, the publication of mugshots of accused persons, not mere suspects, particularly those in the public eye or whose images are not readily available, serves a legitimate and strategic law enforcement function. Corruption cases often involve public officials, politically exposed persons, or individuals with significant influence. Publishing their images enables the public to identify those formally charged, reduces misinformation, and reinforces the principle that no one is above the law. You don't agree?
That's what I'm saying to you. Nobody is against publishing the name. You can't do a criminal trial without a charge sheet. The charge sheet will show the person's name. So nobody is against that. So the issue, we cannot create a law or pass law, and the target will be the fact that because of a certain class of people, there are thousands of people who are arrested on a daily basis. There are thousands of people who go through the criminal justice system who are not politicians, who are not notable people.
That's right.
So if they are going to suffer this, that's a bigger problem as compared to two politicians. Our problem or our focus should not be on the politicians. You understand?
Does it help that if the publication is made,
yes,
perhaps maybe they live around you, other people know that they are involved in some wrongdoing, they can help law enforcement to say, this person you are prosecuting. I think around our area, recently he bought a Bentley. The last time he bought a house there, and you are asking about all of these things. So maybe the name is not enough. The face can help. Maybe they are trying to run away, and then somebody can say, this is the person who is running away.
Leave that to the media to do.
The media?
Listen, I'm saying to you that if Joy News, if the OSP says that I have charged X, Y, Z with these charges, multimedia will put up the image there.
That's right.
Yes. So
you say there's no wrong with that.
I'm saying that the media reportage, because there's a right of the public to know. So nobody can stop the media from saying that we are putting, we are injuncting the media from public.
It's the same thing. Put out the person's image. This one is also putting out the.
I'm saying that.
So where is the wrong?
I'm saying to you that two people work in two different areas.
Okay.
One in the court, one in the court of public opinion. Let the public opinion, let those in the public opinion have their say.
Okay.
But once you are in the justice system, there is a tendency for you to confuse.
I'm bringing my viewers in. We were showing the blurred faces.
Yes.
And you see a lot of it. Police will arrest you.
Yeah, police.
They will take a picture, immediately they arrest you, and then they will blur your face.
Something. Even you would remember that we had to fight this before the police started blurring the images of people. Why?
That's correct.
So if the police are blurring the images of people...
Suspects.
Suspects. If the police are blurring the images of suspects, some of them have been charged, but they don't publish the Markshots.
No. So let's take it gradually. We're educating the public.
Yes.
That there's a difference between a suspect and a person who has been charged, correct?
Yes.
Suspect could mean simply that you are being investigated.
Perfect.
Charge means we have concluded investigations and we take the view that you have done wrong. We have put you before a court.
I refer you to the case of Helwer and Chief Constable of Derbyshire. It says that the police is entitled to disclose confidential information where this is reasonably required for them to carry out their public duties. For example, there's an obvious and vital public interest in the police being free to use a police markshot of a suspected criminal which is prima facie confidential when investigating an alleged offense and trying to apprehend him. So I'm saying to you, recently you see that what the police does is that after they release the suspect's blurred
Tony, you are calling us from where? What do you have to say quickly? What question do you have?
Yes, something. Thank you. My question is, you see, the people that put out the image, who are the investigators? I think there's a big problem with that because they are the people doing the investigation, and they should understand or know that the people are still accused. It is the law that convicts them, and until then...
No, the people whose images... Hold on, Tony. Tony, hold on.
Yeah.
We are educating the public here. You must know we are talking about two different situations. In the Markshots we put up, Mustafa Hamid and co., they are not suspects. They are accused. They have been charged. So it's different. So when you say those people investigating them know that they are not accused, you are wrong because they are accused. Hi, Tony. Okay, I lost Tony.
So I'm saying to you that it is within this context that you find that
Martin Jame. Hello, Martin.
Hello, Samson.
Hi. What's your question? Quick.
Yeah, please. I think it's not proper for them to release the pictures, the images, because looking at how the people are even mocking them on the social media and everything. So if such pictures are released outside, and at the end of the trial, those people are acquitted and discharged. Their political opponents or their enemies can still use it to mock them later. So I think it's better they allow the process to go to the end.
Thank you very much. Elliot is coming. Elliot, let me pick you. I wanted to ask you a question. If somebody is acquitted and discharged, like he said, their political opponents can still use it against them. Is that possible?
It could be a potential for libel.
Is it possible?
It's possible. But I'm saying that
somebody is acquitted and discharged, and you still try to project them that they are accused people guilty of something.
So no, I'm saying to you, let's take it as a time. You have, in politics, somebody can pick a person's image. Although the person has been acquitted, the person is still using the image. Now, it's for the person, it becomes a civil aspect between the person who has been acquitted and the person who is using the image. As for the law enforcement, they can't use the image anymore because of Section 108 of Act 30.
Who is the next? Elliot, let's hear you. Hi, Elliot. You're calling from Achimota. Quick.
Yes. I don't think there's a problem with the mark. You know, if you are a criminal, you remain a criminal. In this case, the man has been accused, and then he's standing trial, isn't it? The whole world should know that this is a criminal that is standing trial.
Okay.
To bring it the Markshots.
So Elliot,
Yeah.
when a person is accused, until they have admitted their guilt or have been convicted, you can't call them a criminal.
Good. I get you on that point.
Fred, you are calling us from Kumasi. Hello, Fred. Fred, quick.
Yeah, I just find out that if police are not ready to show the faces of the arrested people or suspected people, why should they even show their faces? Because I know their bodies and their faces are all bad. So if their faces are not to be seen, why should they even allow the camera to capture their bodies?
As you heard in the explanation earlier, the reason your face is not shown by the law enforcement is that you are under investigation. That is a suspect. But once you have been charged, that's a different view. And that's why some of the court decisions we have shared with you, they say once the person is charged, there's no problem with showing their face, even though Kofi has an issue with that. Okay, yes. Okay, my production tells me I can't take a further call. You were saying something that's instructive, that if someone has been acquitted and discharged of a criminal offense, somebody is allowed to still use the...
No, that's what I'm saying. I'm saying that if, as he was saying that his political opponents can use those images, if they use those images, those political opponents will be liable for defamation.
Why would they be liable for defamation?
No, because you are trying to impute a crime that he has been acquitted of.
Exactly. So they are no more...
Yes, but I'm saying to you, I'm just saying to you, that that is the you see your callers are saying that they are referring to people as criminals. And I'm just saying to you, these are the peers, these are your peers that are going to determine your fate in court.
But when they see the people in the media, they are covering every day, the person is going to court, coming out, there's no problem with that.
You are a practitioner in the courts. You will tell your client even how to dress to court.
On this platform, I'm asking you questions. Stop putting the questions.
You will tell your client how to even talk to the media. You understand?
Yes.
Because you have to manage the public.
When they are talking, is their faces out there?
Francis, something. You have to manage the public image.
Okay.
And the public image you manage for your clients is very, very important because you want to give your client the benefit of the doubt. You want to give your client the full right he has under law. So the obligation that the prosecution has in adducing evidence is very, very important.
Okay.
And that obligation cannot... Something, I want to read something to you.
Quick.
Section 74 of the OSP Act.
Okay.
An authorized officer who is in possession of information in the performance of his functions under this act shall not communicate the information to an unauthorized person or disclose the personal details of a person who has given information to any person.
How is this related to Markshots?
I'm saying to you that under the Data Protection Act, personal data is protected.
Exemptions are there.
And I'm saying that the exemptions there does not relate to what the OSP has done. It doesn't. It doesn't.
But you are using, you see, these laws you are referring to,
yes,
they are the same that are in Atlanta elsewhere that they are using to put out Markshots.
No.
They are the same that are in other countries. So how can you use the same to say that it's against this year?
I'm saying to you that the laws that we have seen,
all right,
or the decisions from the U.S. Supreme Court is that
and the UK Supreme Court
is may.
The
question is may. The U.S. Supreme Court that I cited earlier on.
Emphatic that once a person is charged, Markshots can be released.
The accused person, you cannot release the Markshots of a person. That's what I'm saying. That have you seen Thomas Partey's picture? The Crown Prosecution.
It's a discretion. So if they decide that they don't want to release it, it's different. If they release it, what crime would they have committed? What
the
offense?
Crown Prosecution Service recently.
No, it's a question I'm asking you.
Let me read.
They have a discretion.
Something. Let me read.
Our time is up. Our time is up.
Specifically, in respect of images, the police has a legal copyright as an owner, are responsible for releasing an offender's custody's photograph. The image may be released upon a guilty verdict unless there is a court order or a legitimate policing purpose preventing their identification. Images may be released as soon as possible after the verdict to allow the media to publish them.
You said this is the Crown Court.
Crown Prosecution Service recently.
Prosecution Service.
Yes.
I've read you Supreme Court decision of the UK, where they say that once the person is charged, they can release the shot. Samuel Kofi Nartey is editor with Ghana Law Hub. Thank you very much. We also had Korea Dodu, senior partner of Egality Law, joining us. Different point of views on the matter of Markshots. Have a good afternoon. This has been The Law. It's your legal light. It is your help law.